Hello. So in this unit on the United States Constitution, we plan to analyze some of the main issues with the U.S. Constitution, both at the time of ratification and subsequently moving forward. We want to look at some of the political theory behind it, as well as some of the choices and the challenges facing the framers of the Constitution as they emerged from this period of the Revolutionary War and this weak central government under the Articles of Confederation, which they subsequently rejected. So John Adams was a leader, one of the leaders of the American Revolution, the second president of the United States. He was George Washington's vice president. We actually meet him in American public history first in revolutionary Boston. He's a Bostonian, he's a lawyer, um, and he's going to become famous during an incident known as the Boston Massacre. There is a protest, some would call it a mob, which was harassing a group of British soldiers at a customs house in the port of Boston. They subsequently wind up firing on this group, injuring and killing a few. Um, and then the people of Boston demand a trial, demand that these people be hung. John Adams is going to offer his services to represent and defend these British soldiers. He takes a quite unpopular view. In his opening statement defending these men, he makes the statement that society should be a government. Society should be governed by laws and not necessarily by men. That they should have a government of laws and not of men. And what he's expressing in particular is this mistrust of the mob, of this group of individuals that are demanding what kind of justice? They're not really demanding legal justice, they're demanding extrajudicial justice. They're demanding on taking these men, and really what they want to do is rip them apart. They want to hang them. And so Adams, like his counterparts during the revolution and during the framing of the Constitution, have this fear of the majority. They have fear of the mob, fear of not just individuals, but groups of men that are just like individuals, capable of injustice and tyranny. What's important also about the observation, and Adams makes a few very keen observations about government, and especially government in the Americas, is this. Well, individuals, personnel, actually have had considerable impact on American policy and on American government, maybe disproportionately so. We have seen government officials, public figures impact American policies, American politics in ways that are, again, disproportionate. Conversely, in a democracy, we say that in a democracy, the majority should get their way most of the time. And so we have these forces. Disproportionately powerful individuals are part of the story of American politics. But also, to what extent should we defer to the majority? To what extent should we defer to the unbridled forces of democracy in a just and proper government? And so Adams is important because he really stresses some of the suspicions and the fears of the revolutionary generation during the early republic period, as well as that of the Constitutional Convention, of these men who really aren't sure where this balance ought to be struck. And so I hope to introduce some of the um, more interesting themes, more interesting questions regarding our interpretation of the Constitution in this lecture, in this slide. So rather than reading through the textbook and giving you an outline of how many seats in the House, how many seats in the Senate, I want to get at some of the um, really essential conflicts and compromises that ultimately led to the production and ratification of the Constitution. One of the big questions in this unit, and as we make the transition away from the early series of founding documents, the Declaration of Independence, the Articles of Confederation, making our way to the Constitution, the question we should ask ourselves is, well, we really feel like the Declaration of Independence expresses a certain American spirit. Why don't we see more of the Declaration of Independence in the American Constitution? And if we really think about, if we have to distill the impact of the American Declaration of Independence to one word, probably most of us would say that that word is equality. And the word equality is conspicuously missing from the American Constitution in its original draft. The word equality itself will not appear in the American Constitution until after the American Civil War. And so one way of looking at why don't we see more of the Declaration of Independence, which is not a legal doctrine, in this law of the land, the Constitution, that rather than fixing the issues of the Articles of Confederation, is going to propose a different system of government altogether. This issue deals with timing. The fact is that the Declaration of Independence comes at a very early time in the war. And the Revolutionary War takes a long time. People say it is the war that will never end. So the war starts around 1775. It winds up ending between 1783, 1784, depending on how you date it. During that time, Americans, especially politicians, legislators, magistrates, they get valuable experience in government. And they're going to take this experience, practical experience, not the idealism of the Declaration of Independence, but the practical experience of governing their states to the Constitutional Convention, and they're going to apply those lessons to the new government that's going to be the federal government, the new national government. As a result, many institutions that Americans in 1776 probably would have never conceded to actually emerge and have some support and substantial consensus behind them. And so one of these institutions is, well, it's not so much the existence of a legislative body, a body that's going to, an assembly that's going to make the laws, but the idea that the assembly, the legislative body, should be bicameral. There should be an upper and a lower chamber. There are a number of states which early on choose to go with a unicameral legislature, a single assembly. Famously, Pennsylvania has a unicameral legislature, and the term limits are 1 year. And so what they find is that this is an extremely responsive assembly, it produces extremely responsive government to the will of the people. People are electing representatives, those elections really matter, and they affect policy. But what they find out in Pennsylvania is that actually government legislation and policy becomes too fast, too responsive. It becomes chaotic. And so the solution in Pennsylvania and some of these other states over time is, what do? They adopt bicameralism, an upper and lower house. There will be one chamber that we will allow legislation to ferment and this kind of energy to begin and to try to address the issues of the people. But in the other chamber, we will let some of those issues, especially the passions driving those issues, we're going to let those cool. We're going to let those slow down. And so by adopting the institution of bicameralism, many states are able to slow the process of legislation and thereby establish some stability rather than producing legislation, then changing it the next year, the next election cycle. They're able to fix some of these laws, fix some of these policies. But the result, and again, this happens over time, these men are learning this. The result is now there isn't as much legislation. Now what they have is the other side. They have gridlock. So the government is not too responsive. It's not too quick. It's not rash or hasty. It's actually too slow. It's unresponsive. The two chambers can't necessarily agree. And so Pennsylvania is one of the slowest states as well. They adopt this role, a chief magistrate, an executive. They call it a governor. But many of these states over time, what will they do? They will resemble, really, they'll resemble what they know. Many of the state governments will resemble the British model, an upper and lower house, a chief magistrate. It's not a king. They will be elected. Okay? But they recognize that there is a role for chief magistrate to break gridlock in the assembly, but also to make some very, very important decisions that we can't really debate or considering committees. They need to be made immediately with a sense of urgency. And so the executive is something, the position of executive, something that evolves as these men are engaged in state government. And so the legislative branch, the Congress, and the executive branch, the president, are going to be things that are going to really inform the constitutional debate. Now, the way that the Congress is going to be created under the Constitution is going to represent a very important compromise. And it's actually a series of interlocking compromises. The people at the Constitutional Convention have an acumen, a talent for making compromises and making deals. It is noteworthy that they're making these deals, these compromises behind closed doors. There's no transparency. This is not an open hearing. There aren't public records. They're doing these behind the scenes. But the series of compromises which result in our system of bicameralism are very important, because not only will they lead to the creation of the union, they will also lead to, well, disunion and the fighting of a civil war. So the way that this story begins is first this battle between the larger states and the smaller states. The larger, more populated states demanded that congressional representation be predicated on the size of a population. What they wanted was there to be a census, and the states with more people residing within their borders would have more representatives in Congress. The smaller states disagreed with this. They said that under the Articles of Confederation, every state had equal political power, equal representation, and that should be the case under the new government in the new Constitution. They wanted equal representation. The compromise, which became known as the Great Compromise, emanated from this bicameral solution. The big states would have the House of Representatives, which was based on proportional representation, meaning based on population. And this was underpinned by the mechanism of apportionment. Okay? So states would be given apportioned representatives based on their population. In the Senate was a deference to the interests of the smaller states, the second half of the compromise. The American Senate, every state would have the same amount of representatives. So proportional representation based on population in the House of Representatives, equal representation in the Senate, every state getting 2 representatives. Now, this wasn't the end of the story. There was one institution that was complicating this compromise. What would the basis of apportionment be? The southern states, some of which, like South Carolina, had black majorities, they wanted to count everyone in the census. What this would do is they would show that they have more residents in their states, and they would get more representatives in the House. And as a result, they would also get more delegates in the Electoral College. The stakes were quite high in apportionment, because not only does apportionment affect the representatives in Congress, it also affects the state's ability to elect the president. Again, the president would not be elected directly. He would be elected through Electoral College. And the number of electors was directly tied to the number of representatives in Congress. It was basically the number of representatives in the House plus the number of representatives in the Senate. That's how many electors a state would have for the purposes of electing a president. So the stakes were quite high. The northern states rejected this idea of counting slaves. They said, look, these people have no legal rights, no legal status at all. How can we count them for the purposes of political representation? But it was very important that to understand that the Constitution was a historical document, an expression of a certain time and a certain spirit of the time. And the spirit of the time was informed by a particular economic reality, which was this: the northern interests and the northern merchants following the American Revolutionary War were really facing economic depression. The only source of capital and wealth that the Americans had was Southern tobacco. And so while politically Northern interests rejected this idea of counting slaves for the purposes of political representation, for political power, to inform the formula of political power in the new government, they had to concede to these Southern tobacco interests, or else they wouldn't get a constitution. And remember what the primary objective of these men was: to protect property rights, to have this kind of stable political system. And they weren't willing to sell that. Okay? They weren't willing to fight this battle, this existential battle over slavery, and risk losing the Constitution, risking these protections. And so they conceded to something which was known as the Three-Fifths Rule, the Three-Fifths Compromise, which informed the Great Compromise. It was part of the Great Compromise. Under the Three-Fifths Rule, Southern states would be allowed to count their chattel slaves as 3/5 of a person, despite the fact that they had no political rights at all. Now, in the 1780s, the late 1780s, this made sense. This reflected a certain reality. It also artificially inflated the political power of cotton planters, an economic and political elite, a political minority in the United States. It inflated their political power. They were able to count their slaves. They were able to have more representatives in the House, a greater say in who became president, and they exercised it. For the first 36 years of the presidency, 32 of those years were occupied by a Virginian, by a planter, by a slaveholder. And it wasn't as a matter of ignorance by the northern states or a lack of recognition that slavery was unethical. Many of those states had outlawed slavery. It was simply economically and politically expedient. This is what they had to do in order to get a constitution. That doesn't mean and didn't mean that they were happy about it. Over time, the Three-Fifths Compromise over this issue of slavery, every time the country expanded and brought in more states of the Union, would bring this issue up again. As the demographics of the northern and southern sections of the United States changed and evolved, and as the northern white population grew exponentially faster than that in the South, and changes expectations, changes its view of American politics, the Three-Fifths Rule became a real sore spot, a source of resentment on the part of the northern states, and something that heavily contributed to, well, it contributed to bringing the Union together in the 1780s, but also to ripping it apart during the Civil War. And the expectation was by the framers that the majority of power would reside in the Congress. But they vested the president with executive powers in order to check the Congress and also to make some of the most important and urgent decisions. The president would be the commander in chief of the military. He would be able to appoint, he would be able to appoint important public officials. The way to get to public office in the United States then and today is to either run for, be elected, or be appointed. So the president would make appointments that, again, we didn't want to be subject to debate and congressional inquiry. But the third branch of government was also important for the framers. They believed that in this dynamic between the president and Congress, there was a potential for one to become more powerful than the other. And this is where the third branch would come in. The third branch would keep one of the other two from ganging up and becoming too powerful. So it would establish this kind of system of checks and balances where no one branch of government became too powerful, too dominant, and ultimately tyrannical. Again, they're afraid of tyranny. But the judicial branch, the Supreme Court, represented little more than that. It didn't have its own building when Washington D.C. was designed, and people had very low expectations of, well, just what this branch would do. As we learned over time, however, the judicial branch of the Supreme Court would become not only a co-equal branch of government, serving to check the president and Congress, but actually in certain times in American political history would become the most important branch of government. The other aspect that's really quite interesting in our study and inquiry of American government deals with the process of elections. And so we know that we have these um, uh, unique elections in the United States. So when we vote for representatives of Congress, we do it by congressional district. When we vote for state senators, we do it as a state, we have a statewide election for those. When we vote for president, we have a national election and we have a popular vote, but that's not how you get elected to be president. There's a mechanism, it's called the Electoral College. And when we actually vote for president, we do it state by state. And what we're really voting for are electors from our state. So California has 55 electors, and so in California, if we vote for in the last election, we voted for the Democrat doesn't get all of those popular votes, each individual vote. They get 50, 55 55 votes out of 538. And so we have these kind of unique and somewhat odd elections that we're going to study throughout the remainder of the course. The big question I want us to focus on in this early introduction to the Constitution is this: how important are elections really? And how much importance should we ascribe to them? And it deals with this question of what should the government do? Because one way of looking at elections, and this is, I will call it the Jeffersonian way of looking at elections. Thomas Jefferson, when he was introduced, when he read the Constitution, he said this. He said, the Constitution should belong to the living, meaning that the government shouldn't really be encumbered by the written word, and certainly the written word of our forefathers, those that are dead. And so Jefferson, his perspective on elections was to ascribe more power to American elections, the results of elections, than to the Constitution itself. If you ask Thomas Jefferson, what should the government do? He might tell you the government should do what the people allow it to do. The government and government public officials should do what Americans elected them to do. And the Constitution is something that, well, should reflect the will of the people. The other perspective is one more limited, which says, well, how important are elections? American elections are very important. However, the most important thing that elected officials should do is respect the limits imposed on them by the Constitution. They should respect and abide by the limits of their office. And in this regard, elections are rendered a little bit less important than the limits imposed by the Constitution. And this is something, this kind of battle over majority will and our conception of consent and sovereignty in America, that is really central to our analysis and our study of American government. How much deference, how much importance should we place on elections? And to what extent do uh, uh, losers of elections, to what extent can they rely on the Constitution to perhaps protect them and their country against the radical change which would ensue if, well, the majority will was fully realized as a result of these elections. So the process of elections itself has its quirks and it has its mechanisms that we will study, but the bigger picture of how much we should actually pay attention to elections is more theoretical and maybe more substantial and interesting, especially as we consider things like political change. In particular, the pace of political change was something that really concerned the framers of the Constitution. And so, this dynamic of seeing the Congress with the House as kind of being the most responsive and kind of chaotic body, and then the Senate as the cooling saucer, really slowing down the pace of legislation and and deliberating and considering the implications and the outcomes of prospective laws, the pace of change was a source of concern. A certain cadence, legislation should follow a certain cadence. Um, what happened was uh, the way that the ratification of amendments took place in the Constitution also reflected this kind of mistrust of abrupt change. And so what the actually the framers of the Articles of Confederation came up with was, rather than governing through a simple majority, they were searching for supermajorities. And so to amend the Articles of Confederation, you needed 3/4 of the states to agree, 9 out of 13. This formula was carried over into the Constitution. The framers of the Constitution were afraid of abrupt change. If they weren't, you can imagine that they would say, well, simple majority. You would need a simple majority of states to change the Constitution. They said, no, you need a supermajority, 3 out of 4, which at the time of the Constitution was still 9 out of 13. What they didn't expect and really account for was the rapid territorial expansion which would ensue. Today we don't have 13 states, we have 50 states. However, the three-quarters formula persists. And so today it is much, much exponentially harder to change the Constitution than it was during the ratification. And it's this part that has created a uniquely and quintessentially American dynamic, being this, that changing existing law, changing constitutional law, is extremely difficult and extremely rare. The result has been that interpreting existing law has grown in importance. And so, coming back to that branch, that third branch, the Supreme Court, over time, as change in the law with every state has become more and more difficult, and consensus more and more elusive, interpreting existing law has grown in importance. And this is one of the reasons why the Supreme Court, which again the framers had really modest expectations for, has grown in significance over time. And finally, it's important to understand that this relationship between the states and the federal government, well, it never really was resolved during the Constitutional Convention or subsequent ratification. There is an argument that it's never been resolved. How much power should the states have? How much power should the government have? There was this promise, this allusion to shared power, reflexive power, this allusion by the Federalists that there would be some symmetry in this shared power dynamic between the states and the federal government. This really didn't turn out this way. And over time, what we have seen is the federal government capture more and more and more power over time. The federal government, over the history of the United States, has become much more powerful than the states. And it's another one of these things that in 1776 Americans would have been tremendously suspicious and weary of. But however, over time, that uh, that conception of government and balance of power has changed, and really the federal government has captured much more of a preponderance of political power in the United States. That is not to say that states' rights advocates don't continue to push back on what they perceive to be a bloated and intrusive government. Again, one of these things that really informs political debate and political choices in the United States to this day. Now, when most of us think of the Constitution today, we typically think about the personal freedoms, freedom of speech, the right to a fair trial, some of us the right to bear arms, a freedom of religion. When we're thinking of these personal freedoms, uh, equality under the law, what we're thinking of, well, are the amendments to the Constitution, which flowed originally from a Bill of Rights. The original Bill of Rights, the first 10 amendments to the Constitution, were not originally included in the first document. They were added subsequently, 2 years later. And so some of the things that we really find to be the most important, not how government should be shaped, not how the Congress should be structured, or what the requirements are to be president, or the lifetime appointments of the Supreme Court, or some of these procedural and structural, some of these blueprint foundational elements of government. Those aren't really the things that we think of when we think of the Constitution. We think of our relationship, the individual's relationship to the state, to the national government. Those are found in the original Bill of Rights. And so what's important to acknowledge is that they weren't included. And the question is why? Why were these things, these protections that we hold so near and dear to our heart, that we think of as really quintessentially American things, and the privileges of all residents of the United States, not just citizens, have these protections? Why were they added after the original Constitution? And the story of the Bill of Rights is very important for this reason, because it answers the why question. The reason why is because this wasn't the primary concern. The primary concern of the framers of the Constitution fundamentally was property rights, and defining property rights and establishing a federal government that could build stability and allow for proprietors to rule. The Bill of Rights was added because there was significant pushback by states that when state legislatures, when they read the Constitution, they said, no, this new government is way too large, too bloated. We asked, what happened to the Declaration of Independence? What happened to liberty? What happened to all those things that we fought for against tyranny, against a far off national government? We don't want this. And so, even though it seemed as though the proponents of the Constitution would have enough votes, 9 of the 13 states would ratify, it was also understood that without Virginia and without New York, the two biggest, most important, most populous states, there would be no Constitution. And those states had split conventions. They couldn't agree on whether the Constitution should be ratified. Especially in New York, there was significant pushback. Upstate New York rejected this idea of the Constitution absent a Bill of Rights, and they insisted. They insisted that a list of personal freedoms, liberties, was attached to the Constitution before they would ratify. And this is precisely what happened. And so we owe the Bill of Rights, these protections, personal freedoms that we hold so near and dear, to really these political dissenters known as the Anti-Federalists, who held out ratification. New York provisionally ratified the Constitution and only fully ratified after the Bill of Rights was added. And you will read about how the Bill of Rights was constructed and what the particular laws were, but it's important to make note of how they were construed. The Bill of Rights did not extend federal protection over things like freedom of speech, freedom of religion, the right to bear arms. What it did was create a safe zone where government couldn't intrude. Government couldn't intrude, make laws pertaining to speech, pertaining to religion, pertaining a right to bear arms. It couldn't infringe on these rights. The expression is Congress shall make no laws. And so they are an expression of a space, a public space, where the rights of individuals cannot be encumbered, they cannot be taken away. And so this is a really important dynamic. Okay, it really is a set of rights that exist absent government. Okay, it's a space where no government interference can take place. So a really interesting, not just list of laws and their particulars, but an interesting and important dynamic. Government does not belong here. And so this construction of the Bill of Rights that we give Madison the credit for construing it this way will become contentious as we start looking at things like gun rights and say, well, actually, Congress we ought to be prudent and make laws restricting the right to bear arms. That in and of itself may seem like a pragmatic course of legislation. However, moving into this sphere that we've acknowledged is not supposed to be intruded upon by the government is a step that, well, some Americans will really push back against, not for the sake of guns per se, but under this idea of liberty and independence that the Bill of Rights represented and symbolized. This idea that the Bill of Rights is something more than the sum of its parts, but dismembering it piece by piece somehow may dilute what it means in American politics as well as the American character. And the Bill of Rights, but more importantly, really the Constitution, are difficult documents to read. They're difficult documents to interpret. One way proposed to understanding and interpreting the Constitution today is called original intent, originalism. The idea behind original intent is the belief that if we go back and try to understand the framers' thoughts, their intentions, the consensus that produced the Constitution, then we can be more faithful and we can be more accurate in reading and understanding what they meant and trying to govern ourselves with those intentions and those principles in mind. There are a series of historical facts that really undermine this idea of originalism. And the primary one is this role of compromise in American history. The fact is the consensus behind the Constitution was extremely frail. And while it was successful, it may have been successful precisely because of its careful and intentional use of ambiguity. It also reflected a reality that changed rather quickly. And many of the alliances that helped forge the Constitution fell apart. The reason why they fell apart is because fundamentally the men that came together didn't agree on what they were doing. They didn't agree on the implications of what they had done. The Federalist Papers we referenced before was a series of newspaper articles that were meant to persuade, in particular, New Yorkers to vote for ratification. The prominent authors of the Federalist Papers were James Madison, Alexander Hamilton, and John Jay. And it was Hamilton and Madison, who really formed this coalition, this partnership that pushed for the Constitution, that pushed for the Annapolis Convention, that pushed for the Constitutional Convention, a partnership between a Northerner, a New Yorker, and a Southerner, a Virginian, Madison. These authors, these men, their partnership frayed over their understanding of the Constitution. They broke up. They actually had a nasty breakup. And Hamilton's breakup was nastier with Madison's mentor, Thomas Jefferson. But the breakup nonetheless happened over a fundamental disagreement of what they had accomplished when they ratified the Constitution. Madison believed that by drawing up the Constitution, ratifying it, they were putting a fence, a perimeter, limiting the ability of government to intrude on individuals' lives and on the rights of the states. Hamilton had a different conception. Hamilton believed that they were creating a strong national government and that that strong government had a duty, an obligation to grow, to develop, and especially economically to support, if not subsidize, the commerce, the commercial interests of the United States. They disagreed. They read the same document and they disagreed on the purposes. And so to establish a consensus and original intent amongst those framers of the Constitution who were there is extremely tenuous if we look at the partnerships and how they fell apart. The other thing that Madison and Hamilton agreed on during the ratification was that there should not be factions in American politics. They believed that the new Constitution would protect against factions against political parties. Almost immediately after, they saw a necessity and that political parties would be an essential element of political life in the United States. And they persist today. And so many of the elements of projecting onto the framers of the Constitution a consensus are really erroneous. They really miss some of the nuances and the complexities of these relationships that really were expedient but frayed very, very quickly after. The other challenge to understanding original intent, another idea that really informs the kind of tenuous structure of the Constitution, was this compromise over slavery. And as we referenced to before, it was this tip of the cap to the tobacco economy. But the tobacco economy really falls off almost immediately after the ratification of the Constitution. And the economics that underpin the political arrangement changed drastically. And this was going to inform the conception of the three-fifths rule, but it was also going to inform the expectations of a growing and emerging American society that no longer saw this arrangement as valid. And so taken together, these compromises over competing political perspectives, over what the framers had actually accomplished, and as a result of a prevailing economic situation that changed, really caused a lot of dissension and disagreement over just precisely what had been accomplished when the Constitution was ratified and this government took shape and began to form. Nobody really knew what to expect. And it would be only over time that not just the framers, but their heirs, the heirs of the framers, would begin to realize how much power the government would have and what their ability to affect political change and political outcomes would be. Nonetheless, it is inescapable to look at, unlike the Declaration of Independence, which is not a legal document, the Constitution of the United States is a legal document. But it is not only a legal document, it is also a political document, which means that there is this merging of political theory with practical application. When we look at the Constitution, we are duty bound to study how its application is seen in practice. Do we see these institutions expressed in practice? And if so, how? We have to also understand that amending the Constitution is so difficult and rare. Why? Well, one, because we have the three-quarter mechanism, but also because political consensus of any sort in the United States is elusive. And if we ask John Adams, who observed this kind of lack of consensus during the American Revolution, he would say, yes, this is what you expect. What you expect in American politics, the reason why the Constitution is so difficult to amend, Adams may say, is because a third of the people want one thing and a third of the people want something completely different. And then there's a third that really they don't know what they want. And so changing these laws becomes extremely difficult, which is why judicial review, the role of the Supreme Court, has become so important. Because while every justice and nominee of the Supreme Court will say that they are not a politician, that they abstain from political activity, that they do not have a political agenda. Okay, this is not the case. All of them have a political agenda and training and angle that, whether it's overt or covert, informs their reading and their interpretation of, again, what is a legal but also political document. By interpreting the Constitution, they're committing to a certain political outcome and a certain political action that has grave implications for American society. And I want to circle back around to this discussion that we had of personnel, individuals' biographies affecting the course of American government, affecting the course of American politics, right? So we have this idea that we're going to deal with later in our analysis of the California Constitution. How much democracy should we have? To what extent should we defer to majority rule? But in this last part of this unit on the Constitution, I want to look at the role that individuals have played and the disproportionate role that Chief Justice John Marshall played in the development of federalism in the early republic. So John Marshall was his political background. He was one of the Federalists. He is one of the framers. He's one of the founders of the country, one of the founding fathers. He is a Virginian. He was appointed by John Adams to be his Secretary of State, a very important position. Back then, the heir apparent to the president, it wasn't the vice president, it was actually the Secretary of State. So Marshall, very important in the Adams cabinet. Adams is a prominent political figure. He's the first vice president. He is the heir apparent to Washington. He runs for president in 1796 against Thomas Jefferson. He wins. In 1800, he runs against Thomas Jefferson again, who at this point is his vice president. And Jefferson wins in 1800. And it is a landslide victory for the Jeffersonians. Jefferson has managed to build this opposition party from within the Federalist Party, known as the Jeffersonian Republican Democrats. And what their political agenda is, they are committed to restoring the balance of political power and giving back the majority of political power to the states. They are fearful of Alexander Hamilton. They're fearful of this collective governmental action that seems to favor the commercial interests, the interests in the North. And so they enjoy a sweeping victory in 1800. Thomas Jefferson calls the results of the election of 1800 the Revolution of 1800. As John Adams is finishing up his lame duck presidency, he's in his last days of the presidency, he appoints John Marshall to be the Chief Justice of the Supreme Court. And thereby he cements the legacy of the Federalist Party in American politics, because the Federalists will never win the presidency again, and their power will erode at the national level, but it will persist and remain in the American Supreme Court, where John Marshall will be able to have a fundamental role in building American jurisprudence. It will be Marshall, more than anyone, who will dictate how Americans will read the Constitution and how the Constitution will impact their lives. And he is a Federalist. He does have this vision for a strong federal power, despite the fact that the wave of American elections is sweeping against the Federalists. It is overturning their conception of American government. Nonetheless, he will be there holding the vanguard. And this will be tremendously frustrating for Jefferson, who will appoint a series of judges to the Supreme Court who are intended to dilute the power of Marshall. Marshall, like we said, judges are both legal scholars but also politicians. Marshall is as canny of a politician as there has ever been in American history. He is able to persuade these people that Jefferson, Madison, and Monroe appoint to dilute his power, diminish his status in the Supreme Court. He's able to persuade them of this dynamic. He says, yes, party politics are inescapable, and yes, you have a duty to your president. But he tells them, and they believe him when he tells them, but more important is the power and the prestige of the Supreme Court. He persuades them that they must act in concert in order to bring the court up into being a co-equal branch of government. And so over time, he engineers so many of these legal compromises. He finds himself in the majority in 95% of the Supreme Court cases that he rules in, which is why we kind of, when we remember the action Supreme Court, we say it's the Marshall Court, and we almost ascribe this kind of omnipotence to him. We almost say that it's he who's making these decisions, despite the fact that the court is acting in concert. But he seems to be the orchestrator. He seems to be the leader of this because of his canny political acumen. And so what does the Marshall Court accomplishes? It accomplishes a series of really fundamental rulings, which fundamentally impacts the shape of American government, jurisprudence, and how we interpret the Constitution to this day. The most important thing that we thank and ascribe to John Marshall is the process of judicial review. It is maybe not fair to say that the framers didn't expect the Supreme Court to have legal opinions and help instruct the government on the Constitution. But it's Marshall who really determines, the Marshall Court established the principle that the court not only would it read and interpret the Constitution, it would have the final word. In the case known as Marbury versus Madison, Marshall established this principle of judicial review, with the Supreme Court having the final say on all the laws of the United States. As a Federalist, Marshall also was able to, through a series of court cases, expand the role of the federal government, expand the powers vested in the federal government through a broad reading of the Constitution. The way that Marshall read the Constitution was, he believed that it was greater, the whole was greater than the sum of its parts. He derived implied powers. He inferred powers from the Constitution that were not explicitly stated and written. He, for example, read the preamble. He read sections of the Constitution, and he pulled out clauses. One of the most notable ones is known as the Necessary and Proper Clause, where the Constitution vested within the government things that were necessary and proper to be done, powers that were necessary and proper for the governing of the country. And so he had this broad conception of government that, through a series of decades-long service on the Supreme Court, he would affirm and establish. He really built the floor for American jurisprudence. He established the supremacy of the Constitution over state constitutions. When there was a debate which constitution should prevail, and remember, this is a time when some state constitutions were older than the United States Constitution, the Marshall Court said no. The law of the land, the final say, is the United States Constitution. The United States Constitution had supremacy over state constitutions. And because the American legal system was based on the rule of precedent, this rule of stare decisis, the idea that legal precedents, case laws mattered and needed to be respected. Because Marshall was at the ground floor, he was there where some of the earliest cases were decided, he was able to establish a series of traditions. Much like we say that George Washington established the tradition of serving 2 terms, even though that wasn't explicitly stated in the Constitution, John Marshall, through his service on the Supreme Court, was able to establish numerous traditions, numerous legal precedents that grew the power of the federal government beyond the imagination of any of the framers of the Constitution. This broad scope of federalism that will be responsible for realizing the vision of Hamilton and many of the Federalists. Well, this happened as a result of the leadership of John Marshall on the Supreme Court. And one of the ways that Marshall and the Marshall Court was able to affect practical change and really in ways that we have a hard time measuring was through the extension of federal protection to private contracts. The development of contract law under the Marshall Court the importance of it cannot be overstated. And it happened early in the Marshall Court. In 1819, a very important case came to the Marshall Court, Dartmouth College versus Woodard. And Dartmouth College was a private university in New Hampshire, which had a charter that predated the American Revolution. The members of the board, it seemed as though they were fomenting political dissent in the state throughout New Hampshire. And so one of the solutions by the state legislature was to liquidate this board, to revoke the charter of the university and turn it into a public institution. One, because they didn't like the politics of the board, but two, because it was also in the public interest of New Hampshire to have a public university. The essential question of the case was this: could a state unilaterally void a private contract, in this case, a corporate charter? Okay, there was a legitimate case that New Hampshire was doing this in the name of the public good. What the Marshall Court decided was that no, an individual state could not void a private contract. And the result of this was the understanding that the federal government would protect private contracts. It would protect corporate charters. And the outcome was, not immediately, but over time, was the growth in the confidence in private contracts, in corporate charters in the United States that was necessary to underpin the economic combination, the growth of corporations and corporate businesses in the United States, which ultimately led to the rise of industry and this boom in big business in the United States. And it's, again, impossible to understand the development of big business. It's impossible to understand the power of corporations in the United States and abroad without appreciating the role that contract and corporate law played in the early Marshall Court. So for commercial interests in the United States, for private citizens, this was really an affirmation of their ability to engage in private partnerships without the fear of having states or other individuals void those contracts. But what opponents of Marshall saw was a fundamental challenge to this idea of states' rights. And the question remained, how could a state law challenge federal law with John Marshall being on the bench? And so this really frustrated Marshall's opponents, his political opponents, who saw a slow and steady erosion of states' rights as a result of the interpretations of Marshall and his Supreme Court. And as we move forward, we will see that some of these decisions, as well as broader interpretations of the Constitution, really are the fabric of political debate in America today, and really are the source of uh, disagreement and the source of the choices and challenges that are presented to state and local government today. Constitutional law, both state and local, is really grounded in some of these fundamental disagreements that really emerged during the ratification of the Constitution, and many of which predated the United States.